Très bien, nous allons pouvoir recommencer puisque les connexions.
So we will be able to resume. Now all the connections are working.
What the
Je souhaite
heck?
la bienvenue au.
So welcome back to the same senior officials who were kind enough to remain with us for this second section, accompanied by two additional witnesses who are Ms. Bridget Walsh, Associate Head, Canadian Centre for Cybersecurity, and Mr. Daniel Couillard, who is Director General Cyber Partnership, Canadian Centre for Cybersecurity. I understand that Ms. Walsh is the only one who will be presenting the comments, and you have 5 minutes, Ms. Walsh.
Merci, Monsieur le Président.
Thank you, Chair.
Good afternoon, Chair and members of the committee. Thank you for inviting us today to discuss Bill C-8, an act respecting cybersecurity, amending the Telecommunications Act, and making consequential amendments to other acts. My name is Bridget Walsh. I'm the Associate Head of the Canadian Centre for Cybersecurity, also known as the Cyber Centre, within the Communications Security Establishment Canada. I'm joined by my colleague, Daniel Couillard, Director General Partnerships and Risk Mitigation. Le Centre pour la cybersécurité est l'autorité
The Cyber Centre is Canada's technical authority on cybersecurity. We lead the government's federal response to cybersecurity events, and we serve as a unified source of expert advice
to discuss Canada's cyber threat landscape and the importance of cybersecurity in the context of Bill C-8. I want to begin with a simple truth. Our world has never been more connected. From the smartphones in our pockets to the satellites orbiting above us, from the smartphones in above us, technology has woven itself into the very fabric of our daily lives. It powers our communications, our economies, our healthcare systems, and even our democracies. But with this unprecedented connectivity and reliance on technology, we are exposing ourselves to its vulnerabilities. Whether it's the risk of state-sponsored cyber threats, the exploitation of aging computer systems, or the misuse of artificial intelligence, this interconnection brings with it a complex web of challenges that touch every sector and every Canadian. Aujourd'hui, les auteurs de menaces peuvent contourner.
Today, threat actors can bypass traditional foreign interference and espionage methods by deploying sophisticated, malicious activities with unprecedented reach, all from the comfort of their homes. In fact, through cybercrime as a service platforms, and with a few strokes on a keyboard, anyone with the means to do so can quickly conduct large-scale campaigns to steal sensitive data, disrupt or deny services, and influence public discourse.
In our 2025-2026 National Cyber Threat Assessment, we are increasingly concerned about the enduring resilience of global cybercrime as adversaries refine their methods, embrace new technologies, and collaborate to expand their reach. Mr. Chair, I have a copy of the threat assessment report with me today, available for committee members. The evolving threat environment requires thoughtful and forward-looking measures. Strengthening Canada's cyber defence capabilities is essential, but so is fostering meaningful collaboration between government and industry. By working together, we can move toward a more proactive approach to threat mitigation. To support this, a comprehensive incident reporting framework would help ensure Canada remains responsive and resilient in the face of increasingly sophisticated cyber threats. Le projet de loi C-8 s'appuie sur son prédécesseur.
Bill C-8 builds on its predecessor, Bill C-26, to advance Canada's comprehensive whole-of-society approach to cybersecurity.
CSC will gain no new authorities. This legislation will provide the government with tools and authorities to enhance cyber defenses and protect critical infrastructure. It will establish a regulatory framework for baseline cybersecurity of critical industry sectors, facilitating information sharing with the Cyber Center, and allowing regulators to seek CSC advice and guidance. Bill C-8 underscores the importance of mandatory incident reporting by reinforcing the Cyber Center's role in helping organizations resolve incidents and improving collective ability to detect, respond to, and prevent cyber threats through sharing of cyber threat information. The signalement des incidents nous aide à comprendre.
Incident reporting helps us to understand what transpired, share threat indicators, and strengthen our defenses. The information that the Cyber Center would receive from designated operators under Bill C-8 would be strictly technical because it would focus on indicators of compromised and exploited vulnerabilities.
In closing, let me leave you with this. Cybersecurity is a shared responsibility, and if there's one lesson we've learned in cybersecurity, it is that no single entity, whether an agency, a government, or a company, can succeed alone.
Merci beaucoup, Madame Walsh, ce qui nous amène.
Thank you, Ms. Walsh, and this brings us to MP Lloyd for 6 minutes.
We had you for an hour just before this. It was in camera. We asked some good questions and we got some answers. And so for the interest of transparency, I'm going to kind of re-ask similar questions and hope that we can get the same answers.
I like it.
Now, I noted that under the CSIS Act for their threat reduction measures, that you have to get a warrant in order to move forward from the federal court. It's not clear under this legislation whether the government would need a warrant to move forward with the actions that they're giving themselves the power to do. Why is that?
Thank you, Mr. Chair, for the question. So the powers under C-8 concern the ongoing regulation in terms of the security of underlying infrastructure. So in the instance of telecommunications, it's Bell's network infrastructure. They do not engage with certain charter rights or privacy considerations in that context. That's similarly how telecommunications operators are currently regulated. So, for instance, in the allocation of spectrum licenses that are necessary to run their wireless networks, that's currently an authority under the Minister of Industry. And there's no need for judicial oversight.
So we talked about a specified person in the previous hour, and you told me that they're a legal entity, not necessarily a natural person. There's a concern that when you have legislation that's written to say that the minister has the authority to order the telecoms to cease providing services to a specified person, there's a fear that we're talking about individual Canadians. Can you provide us with, if you believe an individual Canadian is a threat to the telecommunications system, there was degrading the system, disrupting the system, manipulating the system, why is there no requirement for a warrant in that case?
Thank you, Mr. Chair, for the question. In the context, if I understand the question correctly, for instance, in the regarding the authority to withdraw services from an entity. In that context, so first of all, the authorities are scoped in terms of needing to protect the Canadian telecommunications system. So that means that the individual commentary of Canadians or their ongoing traffic online is not germane to that, just in practical terms. So that would be in the context, for instance, of a distributed denial of service attack, which is flooding a network and preventing essentially the operation of it for other Canadians. The use of that authority needs to be reasonably necessary to advance the stated goal. So it can't just be on a whim. It needs to actually be tied to the gravity of the threat that's in question. And we are dealing with circumstances that where time is of the essence, where like these are services that Canadians rely on for life and death, be able to call 911 or to do something, things of that nature. And so there are considerations about being able to move quickly.
Why the secrecy? Like, why are there the secrecy provisions provided in this?
Thank you, Mr. Chair, for the question. So generally speaking, the secrecy provisions are both not necessary and not like operationalizable. So when we're dealing with equipment that applies to all telecom carriers, like 99.9% of the time, we're going to be going out with a public consultation with rules, and we want everyone to know the rules of the road. There can be some specific circumstances where, for instance, an operator has a vulnerability in their network that's very specific, where disclosing that vulnerability would essentially invite hackers to like flood the zone while that operator is trying to get that under control. So that's the use case for the confidential order-making provision. It does include oversight, for instance, notification requirements to NCIRA and SECU so that they have line of sight and ensure that the power is being used appropriately. It's also subject to the annual reports to Parliament. So even though—
Is there an opportunity for judicial review? Like if somebody feels that these decisions are infringing on their charter rights?
Certainly anyone can go to the courts with an application of judicial review. And
but what if it's secret? Like if they've been ordered that they can't say anything, how would they go to the courts?
We still need to consult the affected parties. Like that's a bedrock, that's a provision of the bill, and it's also a bedrock provision of administrative law. So like though the entity affected still needs to have the opportunity to make their case about, you know, how the order may affect them. And they can go to the court, as well as, again, the notification to review bodies and the annual report to Parliament, which even if it doesn't disclose the individual, like the detailed nature of the order, still needs to describe the activities as well as their like necessity.
Is there a time limit on those things? Like it says specified time. I only have 10 seconds left.
Yes.
So.
We have 90 days to notify NCIRA and SECU, and the report to Parliament is tabled annually.
Thanks.
Thank you, MP Lloyd, for these good questions. Let me turn now to MP Akan for 6 minutes.
Thank you, Mr. Chair. Thank you for being with us today. And I was going to ask Ms. Walsh, but Mr. Arbour or Mr. Maxwell, please contribute to the answers. So the Canadian companies have been using offshoring, that is development outside of Canada. The Critical Cyber Systems Protection Act, Part 2 of Bill C2, establishes a fundamental requirement for designated operators who manage vital services such as telecommunications, banking, and energy to mitigate supply chain and third-party risks. If software development is being offshored, the responsibility should still be on the Canadian company which ordered the development, and they should scan and verify the product they receive before they deploy it to the production. How does placing the explicit responsibility on Canadian companies, the designated operators, to establish and maintain comprehensive cybersecurity programs, including steps to identify and manage risk associated with the designated operator supply chain and its use of third-party products and services to ensure compliance with the high Canadian security standards, regardless the physical location of the development or the supports team is?
Thank you very much for the question. So I think this gets to a really important aspect of the bill. And as you say, the obligation is on the designated operator to make sure that any third-party services or products that they use are up to a reasonable standard to mitigate those risks. So the way this would work is that the designated operator would have a cybersecurity program in place, and they would have a plan for how they mitigate that those risks, which means they would have a plan for how they would assess the various services and products that they might contract to be used in their networks. There's advice and guidance that comes from the Cyber Center, and they can use that advice and guidance to understand how best to identify the products and services that will maintain the safety and integrity of their network. And one element of this that will, I think, help the cybersecurity ecosystem writ large is that it means that the, companies that are selling their products and services to critical infrastructure will have to make sure that that their products are secure by design and that they're not sort of rushing to market and fixing potential flaws after the fact.
Thank you. So in addition to the general risk mitigation, foreign state actors and entities from high-risk countries pose direct threats to our national security. How do the expanded emergency powers granted to the governor in council under the Telecommunications Act Part 1, specifically the power under the new Section 15.1 to prohibit a telecommunications service provider from using all products and services provided by a specified person, and direct their removal, provide the government with a precise and necessary tool to safeguard the Canadian telecommunications system against interference, manipulation, disruption, or degradation?
Thank you, Mr. Chair, for the question. Yes, so there are products and services that can be under the control of a hostile adversary, either in terms of the producer of those products and services being subject to extrajudicial oversight or other means by which that they could be used to infiltrate Canadian infrastructure. So in that context, especially given that software is increasingly important, the risk mitigation may not be possible in terms of using that equipment or service. And so therefore, the authority in question gives the government the ability to restrict its use entirely or to have it removed from the Canadian telecommunications system.
Thank you very much. So when considering the scenario where foreign support teams remotely access the runtime environments, it is critical that they adhere to the same mandatory security posture as Canadian employees, ensuring competitive fairness across the sector. So since designated operators must integrate steps into their cybersecurity programs to protect its critical cyber system from being compromised, how does the implementation of mandatory security standards and risk mitigation measures addresses the concern that companies utilizing international supply chains might otherwise gain an unfair economic advantage by circumventing necessary domestic cybersecurity costs?
So if I understand the question, it's a question, you're asking how a company would manage the financial aspect of having to mitigate these risks, and does it put them at a competitive disadvantage, is that right?
Correct.
Okay. So the bill itself does not directly address that. However, what we have looked at in the context of this bill is trying to ensure that we create a cybersecure environment in a way that does not put undue burden on industry. In this particular case, having a cybersecure environment is important because the bigger risk is an incident. One incident can outweigh years of profits and frankly incur so much damage that it would eclipse the expense of trying to keep the environment secure from the get-go. So the bill does not address it directly, but it is meant to protect the Canadian economy and protect the industries themselves in that way, just because the threat and the cost of a cybersecurity is so high if it were to materialize.
Merci beaucoup.
Thank you very much.
Merci, Madame la députée Akan, pour ces...
Thank you, MP Akan, for those words. This turns us over to Mrs. Belfay for 6 minutes. Is the interpretation working? Do you understand French? Very well.
Madame Walsh, mes questions, c'est que...
So, Ms. Walsh, we had a discussion with Ms. Gibson earlier, who said that the government, before drafting Bill 8, noted that there would be some overlapping with other jurisdictions on cybersecurity. Ms. Beaufeuille, sorry, I have to interrupt. It's important not to refer to specific information that we mentioned in an in-camera session. So we know that C8 will no doubt see some overlap with or duplication with the jurisdiction of the provinces and territories. We saw that with other things such as agreements with Hydro-Quebec and the United States, for instance. So you, in your main role where you protect information that is shared with the government. So with Bill C8, how will you be sharing information with the provinces and territories? How exactly will this play out? Because in the outset in your presentation, you indicated that the government cannot be a lone actor, that you have to work with a government, with industry, and you need a team to fight cyber threats. So we also understand that the provinces and territories are in that situation. So how will you go about sharing information with your provincial and territorial partners?
Merci, Monsieur le Président, pour la question. Je vais répondre.
Mr. Chair, thank you for that question. I will answer in English.
Very strong working relationships with our counterparts in all the provinces and territories. So, for example, we meet regularly with those responsible for cybersecurity. We have a working group established that meets in person at least once a year to exchange on cybersecurity issues. And in fact, have discussed Bill C8 and Bill C26, the predecessor, with our counterparts. And really heard from them about the fact that, yes, and Hydro-Quebec is a good example because they are subject to regulation within Quebec. They are subject to regulation within the U.S. because of the transborder energy that they sell, and also would be subject to regulation under Bill C8. So really have a good connection with them to understand their concerns with new regulation and the processes involved. But also we work regularly on a day-to-day basis when it comes to cyber threats. So we work very closely with all critical infrastructure providers and provinces and territories to share threat information. So for example, if I think to a situation where we hear about a cyber incident impacting Canadian critical infrastructure, and while we don't have mandatory reporting requirements today, we receive voluntary reports. We take that information, we understand it, we distill what we can share, so we share that information with critical infrastructure partners, we share that information with provinces and territories, so that everyone is able to take that information and use it to defend their own networks. And I might turn to my colleague Dan Couillard to share a little bit more detail about our interactions with the provinces and territories.
Oui, merci.
Thank you. I'll just continue on that discussion. One of the sectors we've worked extensively with since the Cyber Center creation is the provinces and territories. As my colleague indicated, some incidents are being reported to us now, and since the center opened its doors. In 2024-2025, we had more than 1,400 cyber incidents that have been reported to the Canadian Centre. So in each case, we worked together with other jurisdictions. We shared the information. Often there were cases where certain entities that were regulated cross-border with the United States and with provincial jurisdictions as well and across Canada. These are cases that we're already familiar with and that we've known about for a number of years. What C8 is going to do is that it is going to put in place a different approach. Some incidents will have a mandatory requirement, and the underlying principle of this is that the more data we have in hand, the better we are able to identify the threat and to share that threat with the targeted entity, but as well with the other entities in the sector that can take proactive action to protect themselves. Will also show this beyond the actually targeted sector, because there's a great interconnectivity between the critical infrastructure sectors in Canada, and it's very important for us to be able to respond to a threat. So we're all familiar with this, and C8, in fact, brings us that wealth of information that we will be able to share. So if I may, in C8, there are also sanctions provided for. And I was wondering about this because there is some overlap and some duplication. Hydro-Quebec could, for example, be subjected to double sanction if they violate a portion of C8.
Thank you for the question. The way C8 is created is we rely on the existing regulator for the entities. And the reason we did that was because those regulators already know their business. And so they are already very familiar with working in a regulatory environment where there is another provincial regulator and where they can deconflict. I can't speak to how they would deconflict and whether there could be a case where there would be sort of a double AMP or something of that nature. But what I can say is that we would rely on the existing regulators who are already used to managing provincial and federal regulation in those industries to promote compliance in those industries.
Merci, Madame de Bellefeuille. Monsieur.
Thank you, MP Bellefeuille. MP Gill, for 5 minutes, please.
This is for being here today. My line of questioning is going to be on the freedom of speech and expression. The Canadian Constitution Foundation has raised concern about the civil liberties implications of Bill C-8, subclause 15.2. Would give the minister the ability to make decisions to kick someone off the internet. So my question would be, what safeguards are in place to prevent the government from using cybersecurity as a pretext for silencing speech?
Thank you, Mr. Chair, for the question. Certainly appreciate the importance of the subject raised. There are protections at the outset, during the use of the authority, and after the fact. So, for instance, the policy objective specifies the protection of the Canadian telecommunications system as the overarching scope of action. So individual speech has no bearing on the ability of Bell Canada or Rogers to maintain its network or the reliability of its services. That just has no relation there. There's further precision that the use of the authority needs to be reasonable to the gravity of the nature of the threat that you're trying to combat. And there are criteria established by the Supreme Court in over many decades, but including in the 2019 Vavilov decision that specifies what reasonableness will be. There's other oversight and reporting requirements, including to NCIRA and SECU, and then finally to Parliament.
Okay, thank you for that. Well, it seems that if this legislation is passed within its current form, unamended, we are going to be giving the Minister of Industry the sweeping power with virtually no checks or balances. In theory, the minister could wake up one morning, as one of my other colleagues referred, and not be impressed by a post on social media, going further to basically that it says it poses a threat to our telecommunication services. Without a warrant, without a trial, without any automatic judicial review, the minister could compel Rogers or TELUS to go and seek these people's private data. So what do you have to say about that?
Thank you, Mr. Chair, for the question. Would note the scoping mechanisms that limit any action with respect to the disconnection of services. Furthermore, to the question about personal data. So first, the scoping applies to those considerations as well. So again, like the personal data or browsing history of individual Canadians are not germane to the underlying maintenance or reliability of the telecommunications infrastructure in question. There is a further amendment that was adopted when the bill was C-26 that for greater certainty explicitly prohibits the use. This was already prohibited, but it adds just an extra level of clarity that the order-making powers cannot be used to intercept private communications.
So what measures could be put in place to ensure that this isn't misused or worse, turned into a political tool for the Liberal government against people or organizations that they disagree with?
Exactly.
Thank you, Mr. Chair, for the question. Maybe I would ultimately what the committee decides is the committee's prerogative, so I can't speak on behalf of the committee. I would note that the set of authorities that were introduced with the bill and that were adopted in the previous committee study that, again, add for protection both in the outset of the scoping, so the concerns that are raised are already prohibited within the scoping of the law currently. There are consultation requirements that allow for additional kind of oversight and consideration of the use of those powers. And then there are notification requirements and reporting requirements, including for the narrow confidential use of authorities that ensure oversight.
I have a final question. Multiple civil society groups have raised concern about federal governments trying to grant themselves the power of intrusion on our private lives and under the name of security. Have these organizations been genuinely consulted before the development of this bill?
You have about 15 seconds.
So the short answer is that yes, we received multiple submissions from civil liberties organizations, and I can say for sure that my team looked at them, studied them very carefully, and considered them very carefully, and including submissions that were made to the committee in the previous Parliament. We studied those very carefully.
Merci, député Gill, pour ces questions. Madame la...
Thank you for your questions. MP Donduron, 5 minutes. Thank you very much. And thank you for your answers that are very clear. It's really interesting to hear you. And I'd like to echo the questions put by my colleague with respect to the privacy rights and similar issues.
À qui s'applique la loi exactement? J'entends.
So to whom does this act apply? I've heard a lot of concerns about the simple citizen. Could you really shed light on who this applies to, who is actually targeted by this legislation?
So I can speak to part 2, and then perhaps I can turn to my colleague for part 1. Part 2 would apply only to designated operators who have been established in Schedule 2 of the Act. So currently, the way the Act is written, Schedule 1 lists 4 sectors that, 4 vital services that we need to protect. And then within those sectors, we would then designate through the regulation-making process specific operators. The obligations only act upon those designated operators, so the owners and operators of critical infrastructure. So it's those companies that it would act on.
Merci pour la question.
Thank you for that question. Regarding Schedule 1, in brief, this applies to telecom service providers like Rogers. And regarding the issue about civil rights was raised, and this applies to the network providers because they have the data of individuals and of corporations and companies in Canada. But that is why there are limits as to the scope of their powers, and there are clarifications, such as the one that forbids any intercepting of personal information and public, and that brings more clarity than private information on Canadians. This is not being targeted by those powers. The idea is really to protect the infrastructure networks. So from what I understand is that this does not affect personal data in terms of how the legislation is drafted. To that extent, is it therefore important that we have more protection in place, or perhaps for those people who will not be affected, and you're saying they won't be affected? Well, perhaps
Le sujet des pouvoirs,
The subject of the powers, it is at least really targets communication service providers. That is who this addresses.
par exemple, pour
And there are powers, authorities to collect information from the service providers.
de comprendre
And the objective is to understand, for example, what equipment they're using in their network.
l'information personnelle,
And personal information of Canadians
sujet des décrets ou actes
is not a subject of any order in a specific context. It's just to protect the relevant networks.
Ce pouvoir, c'est
So this authority is directly tied to an order or an order in council
exemple,
for all of the concerned parties mentioned here. I understand that there may be certain contexts where there might be one element in a bill. We look at that, but it's important to read the bill as a whole in order to understand the safeguards that it provides for. Thank you very much. I think one of the topics we haven't yet explored is the impact of cyber threats and ransomware. What is the financial impacts for Canadians from the kind of threats that we're currently seeing?
To crimeware groups that total in the millions, in the hundreds of millions of dollars, but not all of those figures are reported to us. So to understand the complete impact, we have incomplete information. We also know that it's not just the impact of a payment that somebody makes to a criminal that has a financial cost on an organization. It's also the loss in productivity and the recovery from those attacks that's quite expensive. And those sorts of figures are also difficult to understand because those are things that often a private enterprise may disclose as a part of their public reporting, but also may be kept private. So difficult to say.
Merci, Madame Walsh. Désolé de vous interrompre une autre fois. Mais...
Thank you very much. I'm sorry I have to interrupt you yet again, but that is all the time we have for that intervention. Ms. Belfeu, you have 2 minutes and a half. Thank you very much, Mr. Chair. I would like to ask, I'd like to thank Mr. Albo to have answered in French, but I'm always sad to see that the officials don't always master both official languages, but as a Francophone, I'm really pleased that you are answering in French. It's evidence that you do master the language. I have a brief question regarding the providers and the operators. You spoke about the big ones, such as Bell. Now, if I look at how internet is delivered in small rural communities, there's Targo, cooperative SECU in my area, for instance. But do you believe that the requirements that these small and medium-sized enterprises have to meet, will they be able to meet those requirements? Will they have the financial means to meet those requirements? And is there any plan to support small operators to do so?
Monsieur le Président, pour la question.
Thank you, Mr. Chair, for that question.
Ministère ISDE
Our department is quite used to working with small telecom service providers. And it is our objective, in fact, to support those types of companies to promote competition in the sector and to expand the networks in rural and remote areas.
C'est important pour nous.
It is important for us
désigner les règles
to
correspondent
identify the rules to make sure that the rules can be complied with all sizes of suppliers, even the smaller ones. In fact, we have spectrum auctions, and there we have set aside specific provisions for small and medium-sized operators. And that is true as well for the enforcement of the Act. For instance, in our consultations, there is an opportunity to take into account the time that it requires to achieve a specific objective set out in the regulation, or also to meet with the scope. There is a certain risk level that is systematic when it involves a large player. whereas for a small provider, let's say, that has 500 consumers, that's quite different. Very sorry, Ms. Belfait, your turn is already over. MP Lloyd, 5 minutes, please.
Really well, aren't we? So there's been some groups like the Canadian Civil Liberties Association that have talked about encryption standards. There's a fear that this legislation will give unprecedented powers to break encryptions. Is there anything specific in this bill that deals with encryption breaking powers?
Thank you, Mr. Chair, for the question. So there isn't a specific provision governing encryption. However, the ability to break encryption for the purposes of surveillance is out of scope of the powers here. Being able to access individual information for the purposes of law enforcement is certainly an important issue. It's a very hotly discussed topic. We've seen in C2, for instance, but it is deliberately out of scope of this bill. For instance, breaking encryption does not advance the protection of telecommunications network infrastructure. It just has nothing to do with that.
No, thank you for that clarification. I think the argument that has been advanced, and I apologize to these organizations if I've mislabeled their argument, but they talk about the term that the minister can order the telecoms to do anything or refrain from doing anything. And they're saying that that's a very broad kind of power that could lead to the breaking of encryption. Can you kind of describe why? Like, that seems like a very interesting wording to use, refrain from doing anything or doing anything. It seems very broad.
Thank you, Mr. Chair, for the question. The wording is meant to capture the range of risks to the telecom infrastructure that can exist. And so, for instance, one may want to tell a service provider that they cannot use a particular product or service in their network, or that they need to take some positive action to protect their network. But again, a bedrock principle of statutory interpretation is that you need to look at the bill as a whole. For instance, the policy objective at the outset sets the overall scoping. There are additional requirements, for instance, that the order-making power needs to be reasonable to the gravity of the threat, et cetera, et cetera. So those all still apply and structure the government's ability to act.
Thank you. And we talked about personal data. You've said it's outside of the scope of this. We've kind of gone over that. But the Intelligence Commissioner has stated in testimony that this power of the minister to ask the telecoms or to do something or refrain from doing something could give them the ability to ask the telecom providers to provide the private information of Canadians. And I believe the Privacy Commissioner has also raised this concern. Can you elaborate on those concerns, and are they a concern, and why not if not?
Thank you, Mr. Chair, for the question. So the Information Collection Authority in Part 1 is modeled off of the existing Section 37 of the Telecommunications Act that has been in place for decades without incident. It just carried forward because it needs to be applied to the new security network protection authorities. It is still structured within the scope of what can be done to protect the Canadian telecom system and not to advance general security or law enforcement aims. So it is still limited to the order-making authorities and the protection of Canadian telecom systems, as opposed to, and cannot be used to advance a generalized fishing expedition or, investigation into personal information.
Thank you. And in my final time, how is it determined if the minister's decision under this powers is reasonable? Who determines if that's a reasonable thing that the minister has done?
Thank you, Mr. Chair, for the question. So at the outset, first there is consultation on the rules, and we are required to take into consideration what those views are. And then there are notification and transparency requirements after the fact, and then ultimately all decisions of the minister are reviewable by the courts. And the telecom operators are not shy to go to the court. They are, well-resourced and frequently make use of that avenue.
Merci, Monsieur le député Lloyd. Nous terminons avec...
Thank you, MP Lloyd. We're going to end with MP Assassi.
They are very comprehensive responses. My question was, does this legislation now make it mandatory for all these operators to report every single breach that they may experience?
Thank you, Mr. Chair, for the question. So the mandatory reporting requirement appears in Part 2 of the Act. The answer to your question is no. It's not. What the intention there is the legislation will set out the requirement for mandatory reporting, and then the regulations will define exactly what that looks like. I had mentioned earlier that we have had some discussions with Five Eyes counterparts about what their mandatory regimes look like, and those have specifically been on the threshold for reporting. So our colleagues from the Cyber Center certainly aren't interested in receiving information on every single cyber incident. A lot of those are day-to-day things that everybody experienced that we have good traction on. I think what we want to understand is when there's an incident that has a certain level of significance, and so that's what we want reported into the Cyber Center.
And then there's a mention of AMPs in this legislation. So do we have any sense as of yet what the highest administrative monetary penalties would be?
Yes, it's in the bill, and I'm sorry, I don't remember the exact number, but what I can tell you about it is that it's because this is a cross-sectoral framework and different industries have different thresholds, it's set high, but it will be set within a range that is typical for the industry that is being regulated.
Thank you very much. And then last question, if I may. In the information you've provided us, it says cyber incidents cost our economy $5 billion, with Canadian businesses paying nearly $7 million per data breach. Could you just roughly tell us why these data breaches cost companies so much? Are these attempt to pay customers because there's been privacy breaches, or why is it so large?
It's a mix of both.
There are a number of factors. So the first thing that happens is if you have a breach, is a cyber incident or a breach, is that your data can be compromised. So the first thing is that you have to figure out what has been compromised, and that can be incredibly expensive just because you've got to bring experts in to come in and understand what exactly is going on your network, what's been compromised, what has potentially been exfiltrated. And then you have to start putting in place remedies not only from the technical perspective, but you also have to start looking at what your regulatory responsibilities are. Are you now not in compliance? There are privacy laws that are going to come into play, PIPEDA, Privacy Act, all of those types of things. There's notifications, there are lawyers that get involved, there are breach coaches that get involved, and so the costs mount. And the other piece that I think is a little bit more intangible is simply the reputational cost, right? Because often these will become public eventually, and then you start losing customers potentially. So that's how the costs start multiplying very quickly. I don't know if there's...
Yeah, I might add to that a little bit, say too, that from a technical perspective, it's the enormous expense that's paid, as my colleague pointed out, to remediate the situation immediately, but it's also the enormous cost in rebuilding and the losses in revenue that a business may have while that rebuilding occurs. So we know that there's a huge cost not just incurred in the immediate aftermath of the incident, but also in rebuilding their technology to get back up and running.
That is very good. Thank you so much. Ce qui m'amène à vous remercier maintenant tous les.
I would like to thank you very much for having been here with us. And not only would I like to thank you for your attendance, but for your contributions. And I hope you have an excellent day. For the other members, we're going to stay a few moments just to conclude this meeting.
Quelqu'un? Oui, Monsieur Ramsey?
Oui, Mr. Ramsey, yes.
Two motions, donc deux motions à proposer. First one is C12, relates to C12, that in relation to the study of Bill C12, the committee invite members to submit witness lists to the clerk of the committee no later than October 29, 5 p.m., that's tomorrow, that the committee schedule 4 meetings to hear from witnesses, invite the Minister of Public Safety to appear, and invite relevant officials, and that the committee conduct clause-by-clause consideration of the bill after the conclusion of witness testimony on the 4th meeting, and that the committee not adjourn until clause-by-clause as completed. So that's the first motion.
Merci, monsieur le député Ramsey.
Thank you, MP Ramsey. MP Caputo.
MP Ramsey as well. There are lots of moving parts here, so I'll attempt to summarize it all, because I think we have general consensus. I just don't want to miss anything here. So with respect to that was the C12 motion he just read in. I believe that, I'm not sure if he said a minimum of 4 meetings. That was my impression. Minimum of 4 meetings. Okay, my understanding was that it was to say a minimum of 4 meetings, and that one thing that should just be noted, and we can have an agreement or an understanding of an agreement, is that we wouldn't move immediately to clause by clause. For instance, if the witnesses finish their testimony at 1 o'clock, at 1:05, we wouldn't be moving into clause by clause, that we would be taking 2 hours per meeting for clause by clause. I think that was the main issue, the main 2 issues. So Mr. Ramsey saying 4 meetings. My understanding is that the agreement was for a minimum of 4 meetings, so I will just try to get some clarity on that. I believe he's going to be, while I have the floor, I believe he's going to speak about Bill C8.
Would you mind, MP Caputo, to reserve your comments for when the motion is known on C8? J'ai vu Madame de Bellefeuille.
Ms. Bellefeuille? Chair, I'd like to bring an amendment to that motion, if I may. I'll read it. That the committee invites the committees to submit their witness list to the clerk at the latest on November 3rd, 2025 at 4 p.m. That the committee plan for at least 4 meetings at the minimum to hear the witnesses, and invites the Minister of Public Safety to appear before the committee as well as the relevant officials, and that the committee proceed with the clause-by-clause study of the bill during a session set out by the committee following the last witness session, and that the committee take the necessary studies to conduct the clause-by-clause study until it is completed. Chair, I would just like to point out that we found that October 29th was very soon to provide a witness list. So I mentioned up until November 3rd. That gives us sufficient leeway to the clerk to contact the witnesses and to prepare our work session. I agree with my Conservative MPs to say that at the very least we need 4 sessions. That would be much more judicious, and I do not agree quickly moving on after the 4th session, then to move ahead with the clause-by-clause session until it's completed. I think it would be wiser to begin a session with the clause-by-clause after having completed hearing the witnesses. And that is the amendment that I'm moving. Very well.
So
there are 3 items.
First, the minimum of 4 meetings. Second, witness list by November the 3rd, and third, an implicit understanding that we would suspend the meeting after the 4th meeting and would not adjourn, which means that the next meeting would be continuation of the meeting not having been adjourned.
En fait, vous pouvez ajourner, juste faites une réunion.
Okay. So so that's the understanding. So the three things. Is there a unanimous view on this, Madame de Bellefeuille?
Vous avez résumé l'esprit de mon amendement.
Well, you summarized the spirit of my amendment. That is what I intended. I just want us to be clear.
La quatrième séance.
We don't want the fourth session, and it does require four, that if there's a bit of time left, that we immediately jump into the clause by clause late at night. The idea is that we begin after. Is that what you have understood in my amendment? And let me also remind the members that the Immigration Committee is to study the amendments to the Immigrant and Refugee Bill. They will be hearing witnesses, and we will be doing the clause-by-clause study. So I think it's important in my mind that the analysts can provide us with a summary of what they've heard, because we will be doing the clause-by-clause study. As a result, a minimum of 4 sessions, in my mind, seems to be a true minimum, because we have to become aware of the recommendations that are going to be made by the Immigration Committee. The clerk would like to make a few clarifications. I spoke to the clerk from the Immigration Committee, and he indicated to me that once the committee has finished with the witnesses, the committee will be submitting the recommendations to the chair of this committee. So we will be distributing this to the members. Very well.
Consensus, possibly even unanimity on these 3 changes to the motion being produced, and I'll turn to you, MP Ramsey, in a moment. So first, the minimum of 4 meetings. Second, a November the 3rd date by which to submit a list of witnesses. A third, an understanding that this 4th meeting will be followed by other meetings to have the clause-by-clause discussion, but not the same 4th meeting being extended possibly to very late in the day. Donc c'est le consensus que j'entends.
So that is the consensus that I'm hearing, and I do believe that we have. Yes.
Derniers amendements pour moi.
We have the 2 last amendments that I agree with, but I do think that we should adhere to 4 meetings without saying a minimum of 4 meetings. So as far as we're concerned, I think that the number should remain 4. I agree with the 2 other amendments as moved, but we won't have unanimous consent for saying that it's a minimum of 4 meetings.
Je crois qu'il y a eu des discussions.
I do believe that we had some previous discussions, and we had previous agreement arrived at by the leaders and between the offices. I don't think that we can come back to the amendment once the leaders have made an agreement. I think we need to stop turning in circles.
Best taking place outside of such a meeting, my understanding is that there was an agreement to such a motion before it was tabled by MP Ramsey, so we shouldn't perhaps invest our time again in re-litigating all of that. MP Caputo.
Yes. Oh, sorry. Go ahead, Mr.
Thank you. Yeah, I think there may have been some wires crossed here. I do like the November 3rd and the implicit understanding, and frankly, I think to assuage your concerns, I'm fine with the 4 meetings and not saying minimum 4, but I think if there is a really compelling reason to have a 5th meeting, we can discuss that at a different time. But I think 4 is fine for the motion right now.
Okay, thank you, MP Lloyd. Now, what about the date? Is November the 3rd a reasonable date to have a... Yes? Okay, good. Madame Bellefeuille?
Oui, ben, en fait, quand vous avez fait le résumé... Là,
Yes, when you summarized my amendment, I think that we were discussing my amendment in a friendly fashion. That is what I understand. But, Mr. Chair, you did this in English. I want to make sure that I have completely understood. So November 3rd is fine. Everybody agrees that we have 4 meetings of 4 minimum. That's fine. But I'd like to come back to the last part. My amendment states that it might take 1 session, 2 sessions to complete the clause-by-clause study. So my amendment states that after hearing the witnesses, we begin a clause-by-clause study, and we cannot say how many sessions that will take. But yes, then we'll have to be disciplined because we have a great deal of other work to complete. Many of you are waiting for studies, and you also have to complete. You're waiting for studies to be completed or to complete studies. We understand that everybody's time is limited.
Time is the scarcest resources around. MP Caputo.
Thank you. I apologize. I was communicating throughout Madame de Belfay's intervention, but my understanding is there was an agreement for 4. I think that, I would hope that if they're, and I'm only talking about the Conservatives and Liberals, that this happened above my level. If there is a concern, I would hope that we as a committee would be nimble to honor Madame de Belfay's concerns, as in if we need another meeting, I would hope that that this is something that we would address if need be to allay any of her concerns. But I believe that right now we're debating between 4 and a minimum of 4. If 4 it is, with an understanding that if there has to be more meetings, we would readdress. Is that okay?
So there is indeed, I think, a consensus. So is everyone fine with Madame Maldonado?
I just wanted to make sure I follow. I think I had misunderstood the last amendment. I think what we'd like to see is that there be a single meeting for the clause by clause, and that we continue until we have completed this without adjournment. So to have a single meeting.
Oh my God.
This
isn't that difficult.
In that case, there will be a session on another day following the 4th meeting regarding Bill C8. But during that meeting, we absolutely have to complete the clause-by-clause study of C8, if I have understood you correctly.
C12.
Sorry, C12. I'm sorry. C12. Is that correct? Well, that's exactly how a sub-amendment is drafted. That is, we have a single meeting, and then after we've completed the clause-by-clause study. So let's summarize more informally. And what seems to have been accepted with these specific amendments is that we're going to have 4 meetings for C12. Following that 4th meeting, the meeting following immediately after will be the clause-by-clause study, and that will last as it needs to for us to review the clause-by-clause. Then the witness list will be submitted by November 3rd next. Well, I don't agree. My amendment is different. I think that the committee is very rigorous. We do not have the intention to go back to C12, but I don't want us to have one single session. We might spend 2, 3, 4, 5 hours on it. What I thought is that I do not want that. That is the spirit in my amendment. And from what I hear now, Mr. Chair, is that we don't have a subcommittee, so that we're always meeting, we're handling committee business in the major committee. And I think that undermines our working as a committee. Because then we have an agreement, time is flying by, it's 1:15, and almost 3 meetings have ended like this. So personally speaking, if the Conservatives and Liberals agree, they could call the vote, but I will vote against. I don't want to be restricted regarding the clause-by-clause to have 3, 4, 5, 7, 10 hours in a row on the clause-by-clause. I don't want that. And I know that I'll be collaborating, and I know that we'll work very rigorously. And all the better if we can achieve this in the shortest time possible, but I don't want to be limited. I don't want to see a restriction imposed on me through a motion, so I don't know how you'll work this out. But I draft an amendment, whether it be defeated, and we might have another amendment, we can vote. And at the end of the day, we can decide on what we do next.
Monsieur le député Caputo.
Thank you, Mr. Chair. I echo Madame de Belfay's sentiment. I mean, we are all hearing from our various parties. I thought that, we had an agreement in principle, and I don't think consensus is that far away on all of these issues. Typically, though, this would go to a subcommittee. and then that subcommittee can work it out behind closed doors, so to speak, where we all come very prepared to deal with that. I'm not sure it would be myself, Madame de Bellefeuille, yourself, and Mr. Ramsey, I believe, are on the subcommittee. I'm not sure if we can do something like that very quickly in the interim, because it appears that we're not getting anywhere here.
Yes, well, lots of work needs to take place outside of this room and outside of subcommittee work. My understanding, and I was obviously not informed of everything, but my understanding there was an agreement, as MP Caputo said earlier, above our pay grades, which is the right thing to do, because other considerations would have needed to be taken into account in those conversations. So there was an agreement between parties that this motion would be supported. There is, however, an opening to having a change in the date, which would be November the 3rd. But apart from that, my understanding and an agreement was achieved. Mr. Ramsey?
Okay. Information I'm getting, it's we have an agreement that if things break down, on a une entente que si c'est l'article par article, the clause by clause,
If we
we can always suspend the meeting and take it later on. Je ne sais pas si cela va plaire à Madame de Bellefeuille.
I don't know if that will satisfy Mrs. Bellefeuille, but if we could adjourn, we could do it. That is not what we're hoping for. We want to proceed quickly, but if ever that were to be the case, of course, we will be reasonable, and we agree to not begin the clause by clause at the 4th meeting. It will definitely be during the 5th meeting.
Très bien. Alors, c'est ce que je propose de faire. Évidemment, on va voir comment ça se passe.
So that is what I would suggest. Of course, we will see how this plays out. And if the schedule perhaps allows us to deal with everything in one meeting, that is the clause to clause, we'll discuss how to proceed.
Consent to the motion as amended, which is replacing October 29th by November the 3rd, and would seek you consent to that. Is that fair and fine? Good. Which leads us to a second motion that you alluded to, MP Ramsey.
Alors, la deuxième...
Oui, Madame de Bellefeuille.
Ms. Bellefeuille?
Pas là. Alors moi, là, est-ce que vous avez disposé de mon amendement?
Have you disposed of my amendment? Yes.
Du 3 novembre est incorporé.
That is November 3rd.
Okay, so we don't need to sit here and watch the rest of these semantics. Basically, I just wanted to see if that was going to pass unanimously, which is cool, because we're going to get the public safety minister in here to, Gary doesn't know what a PAL is, to show up in committee. And he's always interesting in committee because he gets fired up instantly and loses his cool real quickly. Question period is in just a little over 40 minutes, 42 minutes. There's the link in chat. We will switch over to that. We've got a little bit of a break until we start question period. And then afterwards, there is the Justice Committee, which we're covering. So I've already made the link for that, and you can see it on the channel, but I'll post it in question period and stuff. So we are good to go. What time does question period start? It starts in about 40 minutes. But yeah, I will see you guys in question period, and thanks for tuning in and watching. Cheers, guys.